Hello, everyone, and welcome to today's seminar on harassment. My name is Michael Yates, and I'm an information litigator from the IP and media team here at Taylor Wessing, and I regularly advise on civil harassment issues. In today's session, we're going to deal with the growing issue of protecting staff from online harassment and businesses from cyber attacks. And this follows a number of recent cases we have dealt with for clients in this space, often causing wider reputational security and safety issues. These cases often involve a number of different specialisms, and today we draw together speakers and advisors from across Taylor Wessing's legal spectrum who practice in a number of different areas. Firstly, we have the eminent Sean Nesbitt, head of our International Employment Pensions and Mobility team, who will talk about types of issues employers and employees face and the obligations involved. Then we will hear from Paul Glass, our brilliant head of cyber, who will talk about the types of attacks which employees and businesses can face and what this looks like in practice, sketching out the types of threats which arise and the effects caused. Then you'll hear from me about the civil remedies available in harassment claims and how to deal with anonymous harassers who often hide behind the cloak of anonymity whilst carrying out their attacks. And lastly, and as harassment is a criminal offence as well as a civil wrong, you will hear from my esteemed colleague, Michelle George, who is a hardened criminal lawyer and litigator from our disputes and investigations team, who will talk about taking action via private prosecution or via the police. So kicking things off, let's start with Sean, who will take us through the employment landscape.
Thank you very much, Michael, and good afternoon, everybody. I would rather be an eminent employment lawyer than a hardened criminal lawyer, but I'm not sure that I look very eminent with what looked like a pair of trousers hanging behind me. I'm doing this from my kitchen thanks to a last-minute tech breakdown. Those are not one-dimensional trousers, but a Japanese wall hanging, so I hope that doesn't distract you too much in this piece. What I'm going to just basically run through are some of the real-life situations that employers and businesses have faced over the last 15 years and which are increasing in frequency in our experience. On the slide in front of you, you should see a reference to the circumstances when it's necessary to protect colleagues, often when they are presented as being the face of the business, and at the lowest level, perhaps in recruitment and when decisions have been made not to take people on. It's quite common to get people bombarding you with phone messages, speaking clock messages, or complaints about why somebody hasn't been recruited. But those tend to pass. At the more extreme end, in terms of faces of the business, the idea of harassment and the need to protect employees first really came into focus for me when Huntingdon Life Sciences was being targeted by animal rights campaigners in connection with using monkeys on testing of pharmaceutical products. And in Huntingdon, the business itself, but also their accountants at Deloitte and some of their other professional advisors were targeted by some quite hardcore activities, including threats to kill and threats of violence, which resulted in private prosecutions and also helped form views on the Protection and Harassment Act that you're going to hear about later. So endemic to work is the risk of criticism and potential attack or hostility towards colleagues, either at the most domesticated, benign end when it's just ordinary course of business decisions, or at the more targeted end when the business itself is perhaps in a controversial area of activity, such as arms, pharma testing, and sometimes some of the other high-profile brands that are in the media now. A second area where you can see these issues arise relates to internal affairs. We dealt with something which happened over 12 years ago in an employment tribunal where managers made a decision on a colleague and they left the business. They failed in an employment tribunal. And off and on, over the last decade, that person has successively used the phone to target people, used email messages to target people, increasing in severity of threat, and has developed websites both in the UK and overseas where documents are posted, photographs are posted, details of private lives, sexuality, allegations of their personal behaviour, and even the offering of incentives for harm or threats to kill. So it's possible that through the psychology, perhaps, of and the addictive nature of some of the modern media and the opportunities that they afford, that people can develop a real habit and an increasing habit and tendency to escalate threats, which on the face of it, old poison pen letters might have been fairly benign and harmless to deal with, but we're seeing people recurring and coming back in stronger and stronger forms in ways that mean that employers face colleagues coming to them saying, look, I'm really worried. I could fob this off 5 years ago, but now they know where my daughter is. Now they're alleging X, Y, Z. This is becoming too much. Please do something about it. And thirdly, and this is a growing area, the more brands align themselves with social values and do more engagement around social purpose, as you'll see is covered on the last point, things like Black Lives Matter, transgender rights, when brands comment on those and put themselves out there as having certain values, their spokespeople can attract sort of counter commentary from people who are radically opposed to their beliefs, and particularly in relation to harassment, the Black Lives Matter piece and some of the transgender and orientation campaigns and awareness raising that goes on are likely to attract very significant counter reaction from people who don't share those values and want people to take down or cancel their voices. On the next slide, there's a quick guide to some of the legal obligations that employers have in connection with protecting their people. And the first and most obvious one is the most general one, which is that you have a duty to care for the health and safety of your employees and also of your service providers, your independent contractors or your consultants who are involved in acting as spokespeople or working for you. And you must do what is reasonable to provide safe systems of work. And that can involve, for example, in relation to hostile messages, taking a view that you want to screen out the receipt of messages from strangers and have scanning software and things like that that protect people from what they don't know about, protect them from worry, and from receiving the messages. There's also an implied duty to maintain mutual trust and confidence with employees, and that can involve, in my view, cooperating with them when they come to you in connection with Huntington Life Sciences type campaigns, although you, the employer, might be doing everything you can physically to protect people or shield their identity. If people are nonetheless being harassed online through the various tools that exist, then you may have to act positively to work with them. And if you don't, they might have a claim for unfair dismissal and constructive dismissal if you won't spend the money to provide special protections for them. And then the third area is the general, rather old-fashioned law of agency. That's really the idea that if somebody does something for you and they're going about it in a lawful way and in accordance with what you want, they have the right to be indemnified in relation to any costs they incur and any liabilities they incur in going about it. So it may be, depending on the terms of your engagement with service providers and contractors especially, but look carefully at the small print, you might be required to be liable for protective measures that they themselves take. Now, why am I talking about these somewhat general duties? The answer is that in terms of pure employment law and harassment as we tend to think of it, harassment on the grounds of race, sexuality, orientation, or belief or philosophy, typically, actually the obligations that you owe your staff to protect them from third-party harassment are very limited. You can see the definition of what harassment is there, and it's an absolute no-brainer that where harassment is carried out internally or by other co-workers and colleagues, then employers are liable and they must do something about it. But for third parties, the UK law used to provide for third-party liability, but that got changed a few years ago. And here's an example in the case law in front of me. Retail workers, hospitality workers, care workers often are at the brunt of physical harassment and intimidation, often on the grounds of sex. It's largely women who are harassed according to statistics, but also on the grounds of race or national origin. And in the Basson case, a black care worker was threatened with violence by a mental health patient. And it was held that his employer was not liable to protect him and not liable for any consequences of harassment by the patient because the patient wasn't a co-worker. And our legislation in the UK does not impose third-party liability. It used to, when there had been 2 or more acts of harassment in the past, that you had a sort of third strike rule. Third time unlucky for employer, and they were liable if they failed to take reasonable measures to prevent the harassment. Now, there's nothing in UK law or EU law that imposes a direct liability for unlawful harassment on the grounds of race or sex. And of course, this runs right up against current values in terms of the Me Too movement and also the idea of and also the idea of brand justice. There's lots of organisation going on online among employers, both in terms of their internal activities and their outward-facing activities. Ted Baker, for example, there was an online petition organised through the database run by Organise. Other people can collect data and campaign using an online organisation called Volt. And of course, Google and Uber have had a lot of activism around harassment, and particularly sexual harassment. And so both within the organisation and in terms of external pressure, there are increased opportunities and I think increased frequencies for harassment to occur, and the need to look at what your liabilities are and what practical measures you can take. Last point I'll make before we get into the practicalities with my colleagues is that look out for future political changes in the UK. After the Me Too movement rising up 2 or 3 years ago and parliamentary reporting into the state of harassment protection in the UK, there is a government agenda for action, and it's quite likely that our law will be changed to impose on employers a direct obligation to prevent harassment and liability if they don't take reasonable measures to do that. So watch this space for the position only hardening. And now on to some of the practical pieces and measures you can take under the current law. Here comes Paul.
Thank you very much, Sean. I'm trying to get the slides right, but apologies, I was temporarily kicked from the platform, and so my live view isn't displaying properly. Hopefully there should be a slide at the moment which is headed Online Harassment and Cyber. As Sean said, I'm a partner in the Commercial Tech and Data Group, and I head up the cyber practice at Taylor Wessing. And what I'm going to pick up a bit is what this kind of activity looks like in the real world, and how it sort of tends to play out in terms of activism, harassment activity against either individuals or sometimes crossing over into the company. And this can be activity by external third parties, or sometimes, as Sean mentioned, sometimes the activity itself is by individuals within the company. So that should never be discounted. Most of the examples I'm going to talk about here are where third parties have taken action in harassing either the employees or the company themselves. So what does this look like in reality? It's perhaps stating the obvious. It's a crossover between the sort of virtual and real worlds. So online activity that then has an impact for the individuals in question in both the online world and all too often in the real world. And where we see it from third parties, it's fairly often arising out of activities by our employees in the course of their employment, which has an impact on those third parties. And those third parties can be reasonably, or sometimes, if you're particularly unlucky, quite highly technologically sophisticated. What we fairly often see here is third parties who are individuals who, from a psychological perspective, perceive that they've been wronged in some way. There's a perceived injustice at how the company has treated them, or what we're seeing a bit more of now, as Sean alluded to, perceived injustice at how a group that they feel a part of is being treated by the company or by the individuals in question. And that perceived injustice or perceived that they've been mistreated can then lead to a vendetta either against individual employees or against the company themselves. And in our experience, at least, the individuals who tend to do this are people who do tend to spend a lot of time in the online world, perhaps less time in the real world. And that can result in some interesting views as to what is a perceived injustice or not. Sometimes we have seen behavior like this that is just for fun, or just to prove I can make people's lives more difficult, or just to prove that actually the company in question security is poor, and they'll pick on individuals who they target as a way of trying to demonstrate that, or target the company to show actually you've got a lot of individuals' data and you're not doing a very good job of maintaining that data in a secure fashion. And if you get people who are acting in that kind of way, they tend to view themselves as sort of the good guys. They're out to prove that the company's got it wrong and they're doing it badly. Reality is they can often have a very sort of narrow tunnel vision approach to what is poor security, because they've alighted on a particular issue which they see as a concern, and they probably don't see the rest of the security mechanisms that the company has in place around sort of defense in depth. as to how they actually do manage the security of personal data or confidential information. We've also seen more recently activity by disgruntled employees. The most public example of this being obviously the Morrisons matter, where a senior auditor published online information of over 100,000 Morrisons employees. There's personal name, address, salary, and bank account details, that kind of information. And that kind of issue is starting to become more common. Obviously, the issues that are raised in that situation where it's an internal employee who's publishing generalized data can be different, but it's worth bearing in mind that that kind of thing is becoming more common nowadays. Hopefully, we've just managed to move on to a next slide, which is sort of online harassment and cyber in practice. So what does this look like if a third party or even a disgruntled employee decides that they're going to harass an individual, potentially then moving over into the company? Often it starts with what we call OSINT, so open source intelligence. And looking at it from a third-party point of view, just as an example, this could be an individual who perceives they've been mistreated by the company in some way, and they know who the individual is, who they perceive to be behind that. They'll start looking online for information about that employee. They'll look on the company website. They'll try and find social media that employee uses, and they'll start gathering together that information and trying to build, okay, well, we know what accounts they use. We know how they use those. They then might move on to things like social engineering attacks to find out more information about the individual, and that might be targeted at the employer, or it might be targeted at other online presence that the individual has. And this is fairly classic social engineering, just aimed at gathering more information. And this is an iterative approach. So as the attacker finds out more information about what online profiles an individual uses, they can then try and access that online profile, either using compromised passwords elsewhere that are available for sale on the dark web, or for example, by phishing attacks, and I'll come on to that a bit more in a minute. So it is this iterative approach of trying to gather as much information as possible. And sometimes it stops there. Sometimes it can be simply using those channels to attack somebody. So once they've identified social media accounts, sending them, constantly bombarding with private messages, or constantly replying to anything on Twitter that they tweet with offensive messages or something like that. And that's sort of where it sometimes stops. Where it quite often goes further than this, though, with somebody who feels particularly wronged, is you then get into the territory of looking at account takeover. And this can be via phishing or via using compromised passwords, which somebody hasn't corrected, hasn't changed their password after another breach. And the prime target for this tends to be personal email accounts. So if the harasser has identified what somebody's personal email account is, then accessing that account is the gold mine. That's sort of the ideal in terms of obtaining information about that person. Because once you've accessed that account, then you can fairly typically find out, well, who do they use for online banking? Who are the utility providers? Who are their friends? What's going on in their social life? Find out some intimate details about them. What other social media platforms do they use? And they can then do, find their Instagram account and say, oh, I've changed my password, I've forgotten my password, click on the password, the email then goes to the email account, and thank you very much. The attacker then accesses the change password link, changes the password, takes over other social media accounts, etc. And there have been examples where pretty much the entirety of somebody's online life has been taken over this way, just by people sequentially accessing and then taking over a variety of accounts. In some jurisdictions, this can lead on to SIM swap attacks. This is difficult in the UK. It's more common in the US just because of the way mobile providers deal with some of the issues that make SIM swap attacks easier. And this is where an individual effectively can hijack access to somebody's mobile phone. What that enables then is getting around multi-factor authentication. So if somebody does have two-factor enabled on their email account or their online presence or even their online banking, it's possible sometimes via SIM swap attacks to then try and get around that two-factor authentication. Moving on to sort of the actions that we then see actually taken once this information gathering and sort of potential account takeover side has happened. What's sort of often described as the lowest level of it, so pizzaing. This is ordering a pizza for delivery to somebody's home address, and you now can order pizza online and pay in cryptocurrency if you really want to, just to make it more difficult to identify who's behind it. You may think, well, so what? Somebody's delivered a pizza to a home address. How would you feel if you had somebody deliver a pizza that they were adamant was ordered for you? You had no idea who did it. What this is effectively saying is, I know where you live. And that is a rather more threatening position to be in, where somebody is effectively saying that they know your home address, particularly if there is other activity going on, if there is other online activity going on which is threatening to that individual. Doxing is sort of the next level up that we sometimes see. And this is, as I'm sure some of you know, where information which has been gathered about an individual is dumped online. And it's sort of put out there for anybody to use. And this can be, name, email address, passwords, home address, information about their private life. And it's put out there for anybody and everybody to take advantage of, often specifically with do what you can to harass this person. So it goes from one person harassing somebody to potentially a whole group of people harassing an individual. And we have seen that become a fairly large-scale issue. If somebody is able to get far enough, you can see theft from bank accounts or fraud, opening loans, taking out loans in somebody's name, for example. We do see the publication of intimate details or information online, and this is typically where access to email accounts have been compromised and accessed, and also where cloud storage has been compromised and accessed, and perhaps photos have been accessed that people don't want in the public domain. So all of that is the kind of thing that we do actually see in practice, where a harasser decides that they do want to take serious steps to actually go after an individual. This can also manifest itself with what turns into attacks against the company. And this is either via individuals spilling over into the business or simple attacks against the business. And what we typically see here is you'll see denial of service attacks. It's very easy now to completely anonymously buy quite significant volume of data to fire at a company's websites for DDoS attacks. There'll be social engineering attacks. There may be outright cyber attacks against the business. And what this sometimes spreads over into is the access to personal data. Or confidential information in the business. But with the advent of GDPR and Data Protection Act and similar legislation around the world, people are actually much more aware of the risk to a business if personal data is compromised. So we have seen instances where the attack has been designed to get access to personal data for the purposes of using that as a threat against the business, and harass the business and say, well, I've access to your personal data, your security is terrible, I'm going to tell the press, I'm going to report this to the Information Commissioner or whoever the other appropriate regulators are. So that the risk of harm around that for the business, regulatory investigation, fines, third-party investigation over data breaches is now being used sometimes as a tool by harassers. And if personal data is accessed in that way, it needs to be investigated and potentially notified to regulators, data subjects, as any other data breach. The fact that it's being done in this harassment context doesn't change that. It just means that you've got an additional layer of complexity in the investigation, which needs to be kept in mind at all times. If you do find the business in that situation, then you do need to look at specialist forensic or cyber assistance. This is not a job for standard IT function, especially when you're trying to obtain evidence in a secure and confidential, in a secure manner, which can be deployed later. If harassers obtain confidential information, they threaten to publish that, embarrass the business. The biggest example of that people know about is quite an old one now, but Sony Pictures, obviously. Yeah. And there are things that you can do about that if the attacker doesn't just automatically publish the information. If they threaten the business first, there are potential court remedies to chase down the data, to prevent publication of the data, and it is worth exploring those because we have found those to be quite effective in the past. There are obviously jurisdiction issues around that. We can't get away from it. You have run into issues where if you're trying to chase data which has gone to Russia, it's very hard to actually get any further than the border there effectively. And law enforcement can provide useful assistance sometimes where there is an attack against the business or even against individuals. And those are the points that Michael and Michelle are going to pick up next. Michael's going to talk about what the options are if employees are being harassed from a civil perspective. So I'll hand over to Michael now.
Thank you, Paul. So as mentioned, harassment is a civil wrong as well as a criminal offence, and civil action can be taken against those who harass. It's available to individuals, not companies, who are being harassed and wanted to stop. Going down the civil route can be preferable for a number of reasons. For example, it allows a certain control over the process in terms of proceeding with your claim, agreeing settlements with specific terms, and obtaining court undertakings under a penal notice. Typically, when going down the criminal route, you devolve all these decisions, for example, on timing, arrest, charge, and resolution to the criminal justice system, which can have sometimes unpredictable results, especially as police resources are stretched. There are downsides, of course, to the civil route, such as having to incur your own legal costs, which may not be recoverable from the other side, and the fact that proceedings are public, but the power of having control over the process is often more important. To establish a harassment claim, you need to show that the defendant has undertaken a deliberate, targeted course of conduct which is unreasonable and oppressive and calculated to and has caused alarm and distress. Damages for alarm and distress caused and an injunction are available as the civil remedies here. A course of conduct must take place on at least 2 occasions, and examples I've dealt with include sending 3 anonymous letters to disclose false abuse allegations, publication of hundreds of defamatory and malicious online Instagram videos, paparazzis following and chasing in cars and on foot to obtain photographs, suffering over 30 abusive texts, telephone calls, voice messages, emails, and other messages from an unknown individual, and hacking and stealing private information from personal accounts and publishing those details online. The test for harassment is subjective as well as objective, i.e. it must be a course of conduct which amounts to harassment of another and which the defendant knows or ought to know amounts to harassment. The case law says that the conduct must cross the boundary from the regrettable to the unacceptable to such an extent that it would sustain criminal liability. So the threshold here is high. There are defences to a harassment claim, such as preventing or detecting crime, or that the course of conduct was reasonable. Procedurally, if you have written or contacted the defendant and they've not responded or refused to accept the claim and settle via some form of written or court undertakings, you must proceed with a claim under the abbreviated Part 8 civil procedure process. This is unless the harassment arises from publication, in which case recent changes to the civil procedure rules mean that the claim must be issued under the longer Part 7 route instead. Interim injunctions are available to stop harassment, which may have just started, as well as final injunctions attained at the end of court proceedings. And if applying for an interim injunction, you'll need to consider whether you give notice to the defendant, whether you've got a situation where it's more appropriate to apply without notice. You'll need to also consider whether Section 12 of the Human Rights Act applies if the case involves speech, or whether, if blackmail is involved, you might want to consider, for example, proceeding with your claim under the protection of anonymity, which might be possible. One of the key points here is to consider the terms of the injunction you want, because the courts can knock back claimants if they are unrealistic or impractical in terms of what they ask for. The benefit of obtaining an injunction, have an order with a penal notice on it, which you can serve on the defendant, which is obviously a very strong test. Away from the actual remedy, there are where, whilst you'll know, in some cases you'll know who is harassing your employees, in many cases you won't, and you won't have a name or an address to serve court. For example, receive anonymous messages or texts or letters, or you may know the name of the social media used to harass, but not the details of the person. Is a cloak of and continue their harassment. In these types of cases, there are 2 broad options available for proceeding. Firstly, you can obtain a Norwich pharmacal order to request the disclosure of the underlying details of, for example, the social media or email accounts or phone numbers being used to carry out the harassment from those who operate those services, such as telephone companies or ISPs. You can then use those details, which are hopefully real, but not always real, to track down the defendant. And this is often very effective in tandem with private investigators who use online open source information to track people down. The other option is to sue what we call persons unknown and use any interest by the defendant in the course of those proceedings, and to use the order to shut down the apparatus the harasser is using to carry out that harassment. So just in a bit more detail, in relation to the first option, to obtain a Norwich pharmacal order, and I've set some more details out on the slide there, you have to show that the telco or ISP is caught up in the wrong, i.e. the harassment. Likely to have information which will lead to identifying the defendant case and that there has been wrongdoing, that the mere witness rule is not infringed, and that the order is necessary in the interest of justice and is not sought for any improper purpose. You also have to give the cross undertaking. Now, practically speaking, to save costs, an applicant should write to the respondent asking for the information voluntarily first, or they should ask that they consent to the order or that they will agree not to object to it. And the reason for doing that is that it can make the application process run much more smoothly and avoids making it contentious, which will only increase costs and timings, allowing the harasser to keep harassing in the meantime. You'll also have to pay the respondent's reasonable costs for complying with the order, so ask for an estimate of those up front. Procedurally, unless proceedings are already on foot, you'll need to issue a Part 8 claim form and then make an application supported by the usual statement and draft order and get it listed in front of a master or judge. But the procedure, once you've got to that stage, is quite straightforward, and the courts are fairly used to dealing with these types of applications. A couple of practical points. If you do unmask the defendant from the details you obtain, you should then write to them setting out your case before you run off and sue them, because you need to comply with the what we call the pre-action protocol. There are some complications if the harasser turns out to be a minor, and this is because the litigation proceedings, because a minor cannot conduct proceedings alone. Note that this includes any pre-action settlement with a minor, because the court has to sign off all these settlements where a minor is involved. In some cases, we have had success working with private investigators who visit the minor's house to have a discussion with them and their parents to explain the claim and alleged wrongdoing. We found that once parents are involved and realise the legal ramifications, we found that they tend to want to resolve matters quickly and amicably, and can be a very effective deterrent of stopping their child from reoffending, and sometimes even more effective than a high court judge. The other route, which I mentioned, to dealing with unknown defendants, is to essentially sue them anyway, even though you haven't identified them by name and address. And this is because the law allows defendants who can be defined in a clear way to be sued. This is called persons unknown. This has happened in several cases I've dealt with, one involving persons unknown who sent a series of letters threatening to go to the media with made-up #MeToo allegations, as well as one involving a cyber attacker who stole a bunch of confidential information from a business and then tried to blackmail them for its return. And one case for one of the former members of the pop group One Direction, in order to stop a group of unknown paparazzis from following, watching, chasing, photographing and harassing the individual involved. In all cases, once the interim order was obtained, the resulting court order could then be used to shut down the harassment. However, in return for allowing claimants to proceed in this way, i.e. without knowing the real identity of the defendant, the court requires procedural rules, and I've set them out on the slide there, which if you fail by can mean that you lose the interim injunction and the possibility of ever getting a final order from the court, and the court expects you, certainly in this day and age, to conclude proceedings and not leave. This is what happened in the recent case called v. Pone, the Court of Appeal issued the following helpful guidance. Identity notice of the claim must be effected or via alternative service. So, for example, we once did a case where we served an injunction via a series of text messages rather than by post, but the court will expect you to do that and to be creative. Second guidance is that persons unknown must be defined as anonymous defendants identifiable as having committed specific unlawful acts. Thirdly, the interim relief that you may get should only be granted if there is a sufficiently real and imminent risk of a tort being committed. And lastly, the terms of the injunction must also be sufficiently clear and precise to enable those potentially affected to know what they must not do with clear geographical and temporal limits. So that concludes my comments on the civil process, and I'll now hand you over to Michelle, who's going to talk about the criminal route. Thank you.
Thanks, Michael. So, following on from what Michael said, criminal relief following harassment, just some practical considerations. So, as Michael outlined in relation to civil harassment, there must be a course of conduct, which means more than one incident which causes the person to feel alarmed or distressed. If you have a scenario where your staff have been harassed, this is something that we can help with. And although this presentation focuses on the offence of harassment, it may be available where there is any criminal offence. For example, if harassment has been committed, there are other possible linked offences, such as Offence of Computer Misuse Act or theft. And although there are only a specific set of circumstances where theft of information will be a criminal offence, there are lots of options open to you in the criminal setting. As Michael has set out the legal requirements for harassment, it will be something that you are aware of. If your staff are being harassed, then you should engage with them immediately and try to keep a record or a screenshot evidence of the activities. As Michael stated, obviously with hackers, they can be difficult to identify, and having a record of that evidence will be extremely helpful when you decide your next steps. So, once you have the evidence, what are your options? Obviously, Michael and Sean have talked you through the practical scenarios in relation to how you should treat your employers and what the civil options are. And Paul has talked through some of the more practical issues that might arise. The first option from a criminal perspective is a private prosecution. It means just that. It means prosecuting the offender yourself rather than waiting for the police or a prosecuting authority to do so. And by that, I mean that we would bring the prosecution on your behalf with a formal criminal case against the offender through the criminal courts. And we would, as such, bear the duties of a normal prosecutor and must prove the case beyond reasonable doubt, just as if the police were in control. This is a perfectly reasonable option, which is deployed by many corporate clients who are the victims of crime. This method is likely to achieve the quickest result, particularly where you have strong evidence. We can review your evidence initially and advise you on the strength and the likely offences that might have been committed. From there, if you decide to use the private prosecution route, we can prepare a case summary and effectively summons the individual to appear in court within about 6 weeks, which is much quicker than the option that I'll go on to explain with reporting to the police. Obviously, there are other pros and cons with taking this route. In relation to funding the case, it would need to be initially funded by the client, but there are options, if you are successful, to claim back between 70 and 80% of your costs. And you can also achieve other useful remedies, including the order for an individual to forfeit any stolen property and to ensure that they forfeit any profit deemed to have been made from the proceeds of their crime. If you want to go down this route, we can obviously explain the available options in more detail. But in our experience, it's been very effective, showing that companies take zero-tolerance approaches to such behaviour. As it is litigation, there obviously is some risks, or that the individual receives the summons and does a runner. But these, of course, would be risks that you would take in any event reporting the matter to the police or trying to take civil action. We previously had success with private prosecutions in relation to counterfeit goods, protecting clients' IP rights, and more recently we've considered and proposed this option to one of our tech clients who's had virtual reality headsets stolen. So it's always an option where you have evidence that a criminal offence has been committed. So the second option is the police report or investigation. And I know that this has already been touched upon, and the reason that I've listed it second here is because police resources have become quite scarce. I've been in the criminal justice system, just representing people, to be clear, after that introduction, Michael, for about 7 years, and I've seen the decrease in police force assistance with reporting of crimes. So where we can get the police to engage, this is also a very effective solution. But obviously, if your employees are being harassed, we do appreciate that this is personal. We appreciate how stressful it can be, and that you'll want to do something about it quickly. So if you decide to take this route, we usually suggest that you ask for us to assist you in getting the police engaged and to make sure that whatever you're presenting to the police is in a succinct form, so that they can just literally say, here's the evidence, here's how it meets the criteria for the offence, and then take action. And again, there are a number of actions within the police investigation, depending on what you as the victims want. So, for example, there are out-of-court disposals, such as a harassment warning, which is effectively a notice served on the suspect saying, effectively, please stop this activity, otherwise you will be arrested and you will be interviewed. And again, that's obviously a lower level way of dealing with it, but is often quite effective. The second option, which is obviously usually where the offences are more serious, is for the suspect to be arrested and interviewed. And this can lead to a number of outcomes, including a charge or a different out-of-court disposal. And the police should consider what you want as a victim and the options of outcome. And obviously, depending on what the suspect says and what you want to achieve, we can assist with advising you as to the best options. We've very recently had a success with a US tech client who was being harassed by an individual in the UK, and we assisted them by collating and organising their evidence and providing a summary of that to the UK police. We then liaised with the local police on behalf of our client, to ensure the suspect was arrested and interviewed. In interview, the suspect admitted his part in the criminal activity, and in that case, he was a youth, and as Michael explains, they are often dealt with more leniently or give rise to more complex outcomes. He was giving an out-of-court disposal, but it included a written apology to our client and to the staff who had been affected by his actions. Finally, just to say, as a criminal lawyer, I know that our clients can sometimes think initiating criminal proceedings is quite draconian or unnecessary. However, in our experience, the type of individuals that we're talking about and those who harass or hack companies, particularly those who are under the illusion that they are doing so anonymously or cannot be caught, are not the type of people that would give up easily. And therefore, these processes, as the ones that my colleagues have described, and the threat of criminal proceedings or even taking criminal proceedings may be the necessary deterrent in the circumstances. On that note, if there's any questions, or I will hand back to Michael in case I've missed anything.
Thanks very much, Michelle. Excellent. Well, we don't appear to have any questions, which can only mean good things. Which can only mean we've covered everything in fantastic depth. But you're always welcome to follow up via email. We'll obviously be sending out a recording of this after the event, and any feedback welcome. But unless there are any questions, thank you very much to everyone for tuning in and watching this afternoon. Thank you to Sean, Paul, and Michelle, and see you next time.